My spouse passed. Do I need to go through probate? Hi, I'm Jeff Palomo with Palomo and Associates. We are your estate planning and elder law firm. This is probably the number one question that we get in our firm all of the time. The answer depends completely on how the assets were titled. So, if a spouse owned assets in his or her own name at the time of their death and there were no beneficiaries listed, and the asset was not jointly owned with the spouse, then yes, you will need to go through probate. However, if you were listed as the joint owner, or if you were listed as the beneficiary of the account after your spouse's death, then no, you will not have to. And the good news in Pennsylvania is that the spousal inheritance tax rate is currently 0, which means whether you have to go through probate or not is not going to change the tax effect, that it will be 0 in the state of Pennsylvania for inheritance tax purposes. I recently had a case where everything was jointly owned with the spouse, but unfortunately, the husband had stocks in his name alone at the time of his death. And so yes, we did have to have the wife go down to the courthouse and open up an estate. But honestly, it isn't as bad as it sounds, and it's the only way for the wife to have been able to get those stocks in her name alone. So that's an example of why, in that situation, we did have to go through probate. If you're planning ahead, check. Make sure that all of your accounts are jointly owned with your spouse, or that you have your spouse listed as the beneficiary, if that's how you would like to take care of it. That way your spouse won't have to take the extra steps of going through probate. Well, I hope this helped. Again, my name is Jeff Palomo with Palomo and Associates. If you would like to come to any of our workshops or ask any questions, please give us a call at 717-845-5390. We'd love to help.